Good evening. This is August 18th, 2022. We are at the Littleton Zoning Board of Appeals at the Littleton Town Offices, 37 Shattuck Street, Room 103, Littleton. It's 7 o'clock p.m. and I will open the meeting of the Littleton Zoning Board of Appeals. We have a full night tonight, so I'm going to start with the administrative matters. There are minutes that were circulated for review, and they should be in your packets, and they were from July 21, 2022. So does anybody have any comments on the minutes?
Are these ones we've reviewed before?
No, this was last month.
Okay, do you want to appoint somebody in place of me since I was not at the meeting?
Yes, for the review of the minutes, let's appoint Eli, please. I'm going to have you on the first two hearings, Eli. The first hearing on the minutes, please. There they are. Okay. So everybody got them, and have you had a chance to review them?
The second paragraph, instead of happy, could I put okay?
Wait a minute. What is the second paragraph?
Or the first paragraph, sorry.
Oh, I don't have it. Sorry.
right there,
I
member
pulled the wrong
input.
one out.
Cowley Hollinger indicates she's happy with the 3-foot setback. I'm okay with the 3-foot setback.
Well, let's just say
Satisfied.
satisfied.
Satisfied, fine.
Okay, would you write that in, please, and I'll make sure that Lucia gets the change. Anyone else have any comments?
Yeah,
I caught that one. Yep.
well, it says that Field said A to the first case, and he wasn't here, and I was, and I did say A, so
Aye.
I, whatever that's pronounced, anyway.
Here it is. I got it.
It's not Field.
It is,
It says you were absent.
oh,
You were not.
I was not,
You were
I was
here.
here, I was the
wait a minute. You guys are reading the wrong ones. 1 second.
July 21st, 2022.
Oh, I got it. Yeah, okay.
And it says I was absent, but I was not absent.
I remember you.
You double check the tape.
She probably doesn't recognize.
Gould, Cowley, and Field and Sewell were members. We had 2 alternates, and Rod was absent.
John
And
was not
then-
here.
John
I was not here.
John Field was
was
not here.
absent.
No.
Okay.
Right.
But he
yeah.
did second and
I was-
approve it.
Oh,
That was
I
great
participated.
projection.
Everywhere Field is, Seawall needs to
you
be.
know what? I'm 90, I thought I corrected these because I knew you were not yet sworn in. And are you now sworn in?
Yes.
Okay. So you were absent, but also you weren't sworn in. I called you on the road and you
Correct.
hadn't gotten home yet. Okay. I'm sorry I missed it or screwed it up because I thought I corrected it. Okay. Everywhere it says Field, it's going to be
Seawall.
Sewell.
Sewell,
Sewell, sorry.
Sewell.
not Sewell.
Okay, I'll make that change.
I made him change the note to the town hall the last month because they spelled my name 2 different ways in it.
Okay, anybody else have any input? Okay, I'll take a motion to approve the minutes as amended.
I so move.
Second, please.
Second.
Actually,
Where
I
are you?
have
Oh, I'm sorry,
Eli
Eli.
as the voting, so I'll take his second instead of yours. All those in favor signify by saying aye.
Aye.
Opposed? None. Minutes are approved as amended. Next item on the agenda tonight would be member comments. Let's try to keep them brief so we can start at 7:10 on time. Does anybody have any member comments? I have one. There has been an application made for an alternate seat on the Zoning Board of Appeals. I regret to say I can't remember whose name it was, but it was an impressive resume. He's served on a couple of the other town committees, and I think he'll be a welcome addition to the board. So I don't think it went in on time for review. At the next selectmen's meeting, it'll be 2 weeks from now that they'll interview him. I did want to comment that the way that their town website reads, it doesn't say whose terms are expiring on the 7th and 8th positions, which would be 2 alternate positions. It didn't say whose terms. So I do want to check with 2 of you, I think, and make sure that we're not filling your position. Because they said they're going to interview him to fulfill a position that expires 2024 without saying whose position. So I don't want to inadvertently have them fill one of your positions, because I said to them, it's our practice here to just keep reappointing as long as someone wants to stay. So, just a comment. Next,
Good
any,
through the 23rd.
you're the 23rd.
2023, I think
Okay.
is mine.
And we can't cover Eli because he just learned how to do a,
I know, he can't, he's got to stay now.
But he was an
He's
alternate,
stuck
I
with
think,
us.
through 24, and then when he became a full-time,
Oh, that's true.
then that means, this might be John's
That's a
one they're
good
talking about.
analysis.
Yeah, I have to just double check. Anybody
sure
else
they
have
have to.
comments?
So, that would be him.
No? Okay. Moving right along, then I'm going to declare it 7:10, even though that clock may need another 30 seconds.
actually needs another 3 minutes.
3 minutes, actually.
3 minutes off, actually. According to Google.
We need 3 more minutes?
Yep.
Yeah, I got 7:07.
Okay.
Can't start early,
That's what happens when we have,
No, we can't start early.
especially with all
Do I
these
have
people
the
here.
applicant here on Christina? And do I have abutters to Christina, just so I can identify who's in the room? And if I send around a sign-in sheet, can I ask you to please sign in? Do you have an extra pen to send with it, or send mine and he can bring it back? Thank you very much, Ed.
Let's see if I have an extra. I got one.
Thank you.
So,
Okay, it's close enough to 7:10 that I'm going to call the case. And the first case tonight is a 7:10 PM scheduled case. It's case 22961. It's 23 Christina Street. Petitioners are Jordan Avalos, seeking a variance or a special permit pursuant to section 17327 to reduce the side setback on their lot. Building
Madam Chair.
Commissioner.
I will need to step down as I'm in the butter.
Okay, thank you for that information, and will you take a seat? You're allowed to stay in the room and comment as an abutter, but you're not allowed to vote and input to the board. And because we have one member stepping down, we're going to appoint an alternate. Eli, will you serve as the alternate on this hearing? And Ed Mullen, the building commissioner, has sent around a colored plan to show us the depiction of where the shed is proposed to be. So now,
if I'd known I was gonna get this, I wouldn't have hustled over there.
It was provided by the applicant, the building permit for the shed.
thank you.
mistakes in the past.
I also want to comment that this is a nice application. The applicant put in his deed with the application, so we have the book and page, and we have the correct names, and a nice picture of the shed. I'm going to ask you to come forward. You can bring chairs with you, or just sit in the front row. We're going to ask you to present your case, and the way we do this is that you present first. Then the board will then take turns asking questions of you, and then any abutters who want to speak or any neighbors who want to speak to it can speak to it, and then the board will deliberate and vote. You can respond to anything that's asked of you, okay? And we're pretty informal here, so introduce yourself and start, if you will.
My name's Jordan Avalos at 23 Christina Street. I've been there since the summer of 2009. When I moved in, there was a shed on the property already, an 8x10 shed, in the same location where I'm proposing to build a new, slightly larger shed at the 10x14 dimension. It's a little ambiguous as to where the back of my property is. There is a fence that my neighbors put up 5-6 years ago that is beyond where the shed would be anyway. So anyway, I'm proposing to put a shed kind of in the same footprint as the old one, just slightly larger dimensions. I want to make sure that I'm not within 3 feet of the back edge of the property, wherever that is. And when I spoke to Ed at the building department, he said once we went through this process and we got approval to get close to that back edge of the property again, where there's nothing except some trees and a fence, then we could figure out where that line actually is from a permitting perspective. I may end up being more than 3 feet away from it, given where that footprint actually lies. But regardless, the point is to enlarge the footprint of the shed by a couple of feet and make sure I have enough room for my kids' bikes and stuff in that shed. So that's the plan.
Board members, any questions?
Have you explored other locations?
On my property, I have not. That is the flattest part of the property. It's relatively close to the sidewalk, which is a good exit point for things like lawnmowers and bicycles. The other side of the property slopes downward. It's kind of wet in that back corner, and it abuts more properties in that way. So it's kind of a natural place for it. It's surrounded by trees and fence where it is.
Is there any reason why it can't be 10 feet from the property line?
That would put it basically right in the middle of my backyard, which.
It moved over 7 feet, yeah.
Yeah, and then it would be enlarged by a few feet also. So 10 feet from the back of the property line might not be too far where it is in actuality. It's certainly 10 feet from the fence where my neighbors have their edge of their property. But yeah, the goal is to minimize impact to the usable yard that I already have, which is relatively small.
If I can add to the answer to his question, question that Ms. Cowley asked, and identify the wetlands, if he was to put it in the back corner, he would be within inside the 50-foot buffer.
You weren't asked. Yeah. Board members, please. No other questions?
So you've explored other locations, but because of the wetlands in your backyard, you believe this to be the only location that works for you, correct?
Correct.
But, well, I don't see any reason why it can't move over 10 feet from the line.
Can I?
It's not wet.
But he hasn't, okay, we're not in discussion yet.
Can I make a comment, please? This is treed, as I look at it, standing on Christina Street. You are treed to the rear of the structure, all the way, or just
No,
partially?
there are no trees behind where it would be looking from Christina Street. There are trees immediately to the right of it, following the line, but there is no direct tree behind it.
And what side of this structure is going to be facing your neighbor to the rear? The back of this?
The back.
Okay. I became really sensitive today, of all days, to the structure that's going up at, what do they call it at the Greskowski property? What's the name of that project?
Hager Homestead?
Hager Homestead. Coming down from my house, which is to Head-One Road, going toward downtown, it is horrible.
That
to-
garage
to-
being so
To see
close to the
smack,
property
the back side of the garage. So when I went to your house and rode around the two corners, I thought, how is this going to look to this beautiful, what I consider one of the nicest neighborhoods in Littleton, really, is the lake area. And people come around from both sides. So what are we going to see coming up Christina, and how can we minimize seeing the backside of a barn in your face as you round the corner on whatever that street is down below you?
Yeah, it's a good question. If you're coming up Christina, it's very hard to see where the shed is at all. There is a
Okay.
nice dogwood tree kind of coming up from that angle as you're approaching Loxley Street. If you're coming up Loxley Street, which is actually where the shed will be closest to, you'd be seeing kind of that double door that you see on the side. And then-
Coming from Goldsmith, but what
Correct.
about the other direction up Loxley? That's the one I'm worried about.
Yeah, the one coming up Loxley, there's actually a white fence that belongs to my neighbors at 24 Paula Beth that goes all the way to the edge of my property and takes a left turn, so you can't really see anything until you're at my property. And then what you'll see
And you see
is
the
a
doors.
tree there's a tree right at that corner of their fence, which is a little bit overgrown, but it's kind of there. There's a rhododendron kind of next to that as well, and in between those two plants, you would see that side of the shed that you see in the picture there.
Can I,
But that is not the place that's within, I'm beyond 10 feet from that direction. It's the back direction that's
Yeah,
requested.
you set back far enough to be good.
they're 10 feet to here?
No, this is 10 feet. More.
No, I'm worried about
Yeah,
this.
this is just the 3 feet.
I'm worried about what I see when
You
I
see
come
almost
down
nothing,
Loxley and
because
see
There's
this.
this white fence.
Is that
big
fence
white
still there?
It is.
Yeah, okay.
So
And trees.
that
Okay.
might, if you,
What I'm going to do, sort of expanding on your theme, John Sewell, I don't
Yeah.
expect you to go 10 feet, but can you go more than 3?
That's not the right house.
Most likely, again, what I need help with is identifying where exactly that property
Yeah,
line
that's an
is.
old picture.
So I'd like to be, what I believe would probably be about 5 feet from that line, but I need some help. I would certainly be at least 5 to 7 feet from the fence that already exists.
Yeah, but this is.
And can I get you to put some sort of
There's no
a
neighbors.
shrubbery or flowering bush at that corner just to
Yeah, there's-
soften that impact?
Absolutely, there
I would
already
be
is a
happy
tree
with
there
that.
that
Okay.
that softens the edge of the fence.
I shouldn't say happy, I would be satisfied with that, right?
They've been very cognizant lately when we've given these variances for sheds to be up close to roads.
Sure,
But they don't always look the best,
sure.
and people don't always maintain them the best. And it's kind of nice if there's a little bit of greenery or shrubbery, kind of softening it a little bit when it's close to the road. Sometimes that's the only place it can be. We are in a habit of allowing 3 feet setbacks when that's the only option. I don't know, I think John is trying to say it may not be the only option.
I mean, there's no leach field or septic tank in the way to moving it over.
And then Cheryl was leaning toward you establishing the reason for a variance. This is a variance because you're violating the side setbacks in the zoning code. And so we have to establish that owing to soil shape or topography, this lot is unique. And I understand that there's wetlands. I'm not so convinced that you're unique in the sense that it seemed to be a fairly level lot, and there were other spots that it looked like a shed could go. But I am comfortable looking for a little variance, but not as much as 3 feet on this particular picture, just because it's a bigger lot than we're used to seeing. So let me see. We have to make sure that we don't derogate from the intent and purpose of the zoning bylaw, and there's no substantial detriment. And we can probably get there with what you've and Mr. Mullen have kindly provided to the board. So does anybody have any other questions? Are there any abutters who would like to speak to this petition? Hearing none, I'll take a motion to close the hearing.
Motion to close.
Before we close, do we want to negotiate what we are comfortable with? Why this gentleman can still speak?
If I can make, I guess, or maybe a question I could ask, is the shed that was there, I have no idea when it was built, or whether or not it was in the plans that you all have a record of, but if that back wall of the shed that already existed was acceptable, legal, whatever the right term is, if I maintained that same back wall
When did the shed disappear or come down?
about a month or two ago.
Yeah, that's actually acceptable, because that converts this into a change, extension, or alteration of a pre-existing. And I think we can go there and not have to go as far as a variance, so that's a good point.
I'm just asking that question. What I would propose to do, ideally, would be to set it back about 2 feet from where that was, which would again maintain the footprint of where the shed was, enlarging it by 2 feet in basically all directions.
You mean
which
by
is
set it back 2 feet, further
further
away
towards-
from Loxclair Road? Or?
No, further away from Christina, and about the same from Loxley, which is well over 10 feet from
See,
the-
now we can live with the back wall being where it was.
Mhm.
So that means since this is a bigger shed, it has to come further towards Christina and further towards your backyard. So think of, if we say that this is a grandfathered nonconformity, if this is where the corner of the old shed is, and this is Christina, and this is Loxia, then, or, excuse me, the other way around, Christina and Loxia, then if this is where the old shed is, that's where your grandfathered variant, or grandfathered nonconformity was.
Sure.
Then if you plant that corner right there,
Mhm.
we don't have to do a variance, we can, which is really quite, the restrictions for variance are tough.
Okay.
We could just do a change or alteration, slight increase, you're coming a little further this way, you're going a little further that way, but you're keeping this corner, which is where the nonconformity started.
You're not making the nonconformity any worse.
Does that make sense to you?
It does.
Can you do that? How far away was that?
I believe I can. I mean, it changes the footprint by a couple of feet in a different direction. I may have to take a tree down or so. But, I mean, it's better
Can you
than
come up here
pushing
and
it 10
point,
feet.
can you come up here and point for us, because I'm not understanding? This line here closest to the back lot line, the one you want the 3 feet on,
Yes.
Is that where the old shed was?
It was not, so where the old shed,
Yes, yeah.
the old shed was
Within that,
within
okay.
it.
And you're
So
going
it's,
2
you know,
feet away.
Geometric center was the same, but it grows in all
Okay,
dimensions.
so what I'm
It's
hearing-
unideal.
What I'm hearing you say is that you'd like us to decide this as a variance, because you want to get as close to that 3 feet allowance as you can.
That would be ideal, is to put it back as far as we can, because it's just wasted space back there. There's no visibility between my property and the next, between the fence
Okay.
and the woodlands that are there.
Okay, I'm satisfied that you've satisfied the requirements for variance, and I'm satisfied that your fence in that corner is going to be some, at least some buffer, and that you're going to agree to some sort of planting if we make that as a condition of decision. So I'm satisfied, you have a whole board to convince, but let's close the hearing and let's deliberate.
Motion to close?
Second.
Okay, who wants to start? Eli?
I'm totally fine with it. I think that if it would move any further, it would close it towards Christina. To your point, it would be a little more obvious coming down Loxley. So I think that closest to the lot line would mitigate that.
And Cheryl?
I'm still thinking, can you come back to me?
Okay. John, Sue?
I'm still concerned that we don't meet the requirements that say, you know, there has to be some reason why it can't be anywhere else. Moving it a couple more feet, whatever way, to get it to where it matches where the old building's closestness to the, whatever, to the lot line would meet the requirements. But I understand that, you're concerned about people seeing it, but again, I don't think it meets the requirement of saying it can't go a little further over, because there's nothing stopping it. No wetlands, there's no subsurface thing, it just means a little brush wet, a little more, some bushes, low level brushes have to be moved. I went out and looked at it, and there's really nothing there between just moving it this way a couple feet.
Yeah, I'm familiar with the neighborhood because it's right up the street from me. And I know you've taken a lot of trees down on the property recently, and I thought that particular corner had also been cleaned up a bit, so it seems like there is enough along John's lines that it could be moved down without impeding the general use of the property, even if ideally, barring these rules, you'd like to place it where indicated, but certainly would prefer to have it as indicated where that corner on the old shed, if he could use that same old corner as the marker, that would probably be the best solution, barring obviously anything coming back and with leveling or something unexpected.
And John? Thank you, Kitty.
I don't see that there's much of a problem. I believe that it's a special permit, though, not a variance. You're not creating a new nonconformity. It's already nonconforming in its location.
So, I know I have to come back to, just want to, because of this side of the table making this comment, we are supposed to find that a literal enforcement of the provisions of the chapter would involve a substantial hardship, financial or otherwise, as part of finding for a variance. To John's point, I think if he keeps the back line of what the old shed was, he can go out in both directions as long as he keeps the back line. But once he goes closer to the back lot line than the back line of the old shed, I think it does create a new nonconformity, not the same, not more of the same nonconformity, but creating a new one. And so I think that's cause for variance. Mr. Mullen probably disagrees with me, and we were at a seminar recently where the seminar leader actually disagreed with me and said that any change, extension, or alteration of a pre-existing nonconformity, as you were saying, John, should just be treated as a change, extension, or alteration of pre-existing nonconformity without it being a variance. And the seminar leader said you should let the audience guide you, that if there are abutters who object to it, then absolutely, you bring it before the open meeting and you listen to the abutters. Here we have the ideal situation of having no abutters. And what I do have is some satisfaction, at least on my part, that he's not going to obscure the view, so it's not substantial detriment to the public good, and that he's willing to put up a shrubbery or of some sort. So, again, he thinks it's more than 3, which satisfies you with the 3 feet usually.
No, 3 feet's a minimum.
Yeah.
That I'm uncomfortable going less than, because it
Yeah.
doesn't give people the room to maintain their property without going onto someone else's property. The problem we have is we're not looking just at this case, we're looking at all future buyers, all future use. People on the other side may decide to cut down their trees, may move their fences, may do other things. And I'm sorry, I disagree, where he's changing the back property line and moving closer to his neighbor's property line. That creates a new variance. That's not just a change or alteration. It's not like he's extending it, he's actually moving closer. So I think we have to call that a variance at that point. And I'm not sure he's reached, I mean, this is petty and small, and I would give it to you in a heartbeat, but you just don't reach the threshold of a variance for that. I have no problem with the back wall staying where it is or was currently. But I have a problem in doing a special permit and keeping that back line, as my fellow members said. But I do have a problem going beyond it without giving a variance, and I'm having trouble reaching the threshold for that. There are reasons for our zoning laws and regulations. They have reasons.
Okay, so, what I'd like to do is poll the board, and I think that deliberation was essentially a polling of the board. It sounds to me like this board would be prefer for you to keep the back property line. And so in the sense of negotiating in good spirit, can you live with that if you keep the back property line?
We're talking about just that back property line, but would I be able to grow, so, again, it was an 8 by 10 shed. So
Grow it,
it's-
yes.
It's 2 feet
Yes,
on either
yes,
side, as long
yes.
as it's more than 10 feet from the Locksley Street.
10 feet from Loxley, and you can grow it on the other side.
So
In
you're-
other words, you're increasing the amount of nonconformity of the old shed. Linear.
So you have to maintain no more than 10 to Loxley,
Correct.
and your extra width, whatever it's gone from the old to the new, has to go towards your house, not, you can't like share it.
Or he just has to maintain
Okay.
the
Yep.
distance.
Understood. Yeah, I can live with that.
So I'll take a motion, and I forget, I got a voting alternate here. I'll take a motion to grant, and I think we're going to treat it as a special permit if you keep that back lot line, and I think the board's more comfortable with that than finding variance criteria. So who wants to make the motion?
I move that we grant the special permit conditional on the location as discussed.
Okay, so condition on the back line,
Not variance or a
back line not.
nonconformity
Not being more not being
and not being increased.
closer to the lot line
In the
than
existing shed.
the previously removed shed.
It's only been a couple months.
Yeah, and anybody want a planting?
That'd be
Besides
lovely.
me? I'm not even gonna say what, I mean, a rhodie is fine, or a, whatever. I just want a little greenery there in that corner, if you don't mind.
No problem.
And condition on the planting at the corner of the shed closest to Loxley. Actually, the rear corner. No, the front corner, yeah, yeah.
Yeah, there are plants already there, but
Yeah, fine.
if it looks cluttered, we'll put up another one.
Now.
She's not saying how big or how much or
Yeah, I'm-
anything like that. She's just asking you to make it look pretty.
Okay, second that motion, please.
I'll second.
All those in favor?
Aye.
Opposed? None. You'll have your special permit, and special permits, you don't really have to wait, well, there's an appeal period, but you can start right away on a special permit if you want to take the chances, okay? Good luck to you.
Thank you.
Madam Chair,
And-
I just want to ask if anybody else has arrived.
Yes, thank you.
Has anybody else arrived that hasn't signed in on the sign-in sheet?
Sure. My report, that is not wetlands in the back corner. It might be wet, but it's not wetlands.
He said 50-foot buffer is what he said.
Yeah, I'm not sure where that came from. It's not,
Anthony, can I ask you if there's any way to get air in here? There's so much hot air up at this table. Thank you.
No, both
Showed everyone that.
Thank you very much.
Thank you.
Okay, I'm going to call case number 22-962, 19-20 Dean Lane. Petitioner Matthew Field seeks to overturn the written order of the building commissioner pursuant to 173-6. John, you need to announce your departure first, please, on the record.
John Field, I'm going to recuse myself.
Okay, and I would like to just announce that I have had past business dealings with the Fields dating back to 2017, 2018. I have consulted with the State Ethics Commission and with Town Council and made my disclosure to my appointing authority, which is the Board of Selectmen. So I believe I can sit, I have no financial interest in the outcome of this case, and I believe I can be impartial. The other disclosure.
Do I have to disclose?
don't
I have
think so.
co-broked with them, but not in the last 5 years.
Yeah, I don't think that needs to be disclosed. And the other, comment I want to make is that I also have asked counsel for the town to be present at this hearing, and we are taking the position, and counsel is taking the position, that counsel is here to guide us in interpreting the law and the rules and regulations. He is not here representing either party in this process or deliberation, and he is not allowed to represent one board against another. So I think we have established that he's a neutral player with more legal knowledge than anybody in the room on these matters. And the third thing is, I think we have planning board in the rear, and I think it was a publicly posted or properly posted meeting, so that they're here also. And I'm looking to see if I need to announce on anybody else. I think that's all. So this is an appeal from a decision of the building inspector, where the format is that counsel for the applicant and the appellant will go first. Building inspector will then respond, and then board members will ask questions through the chair only, please, and not at one another, even in conversational way. Let's one at a time and let everybody speak fully. I also have one recusal, so I'm going to appoint Kathleen O'Connor as the voting alternate. Okay, go ahead.
Thank you, members of the board. I'm Jennifer Platt here on behalf of the Fields. This project is at Cooper Farm. It's a result of a long series of negotiations with the town going back to 2015. It's was developed as part of a host community agreement and an open space development where over half of the land at this property was given to the town for open space and to maintain its farmland and for walking trails for the public. Dean Lane was developed under the old over 55 development bylaws. Those have now been superseded, but this was approved back in the day. It's a age-restricted community, and that's important. This was approved by the planning board. We have a special permit which deals with the open space, deals with the over 55 development. The special permit itself doesn't have any reference to affordability. It doesn't reference a percentage. It doesn't reference a number of affordable units. We're all relying on the old bylaws here, and the old bylaws had a 25% affordability requirement, and we're not disputing that. We are making every effort to comply with that. I do want to note that affordability only applies to the over 55 portion of the development. It doesn't apply to the single-family homes at Cooper Farm. It doesn't apply to the farmhouse. It's only the over 55. And it's also important to note that because it is an age-restricted community, even though there's an affordability requirement and there are affordable units there, they don't count for the town's affordable housing inventory. Because of the age restriction, the state has made the determination that these are essentially discriminatory restrictions, and so we can't count it on the town's affordable housing list. The special permit allowed us to build up to 24 units in the over 55 section. due to site conditions, due to primarily the septic capacity of the shared system, this is designed and developed for 16 units. And with 16 units, we would have 25% for affordable units. The town already has for the equivalent of 4 affordable units. There were 3 homes that were built and designed as affordable units, sold as affordable units. They're now occupied as affordable units. The 4th unit, or counting as a 4th unit, ended up being a contribution by the Fields to the town's Affordable Housing Fund for $350,000. We're going to circle back to how that happened, because that's sort of the crux of the matter, why we're here tonight. The farmhouse was part of the host community agreement. The Fields had agreed to gift the farmhouse to the town, and they did. They delivered a deed to the town. We had numbers of meetings with the select board, with the planning board about the house. When the Fields bought the property, the house was in rough shape. I mean, there was graffiti on the outside walls. It was filled with litter. Heating didn't work. Appliances didn't work. They put in significant time and effort to make it look better and actually be livable. But as part of the process, we were in front of both the select board and the planning board and had discussions about, well, given that the house is in such horrible condition, how about if the Fields invest in the property, they do some renovations, do a lot of renovations, and this counts as one of the affordable units. The planning board approved that. We have in your package, in the minutes, the vote here. It was actually a motion made by then Chair Mullen, proposed a motion to accept the house as a count on the affordable units in the Cooper Farm development once the definition of habitable is agreed upon by the Board of Selectmen, with the exception of septic. Member Martinari seconded. All were in favor. So this was approved. This was voted on by the planning board. It was approved. Fields went out, they did all the renovations that were required to make this house habitable. As part of the special permit, we had a requirement to have a site visit to make sure the work was actually done. Our building inspector was there, but as the liaison from the planning board to the select board on this house contribution, and at that site visit, we confirmed a couple of things. One, the work had been done. The house was now habitable. They'd done a lot of work to get it there. And I believe you've been submitted pictures of a new heating system, new floors, new appliances, everything to make it habitable. But as a part of the approval from the planning board, they did not have to, the Fields did not have to upgrade the septic. And the members of the select board who were at this site visit raised the issue of, well, maybe we don't want this house because for the town to put in a new septic system and pay the required rates would cost around $150,000. And that's both a lot of money to put in for the new septic, plus then the town would have to manage and operate the house. So after a lot of back and forth, they came up with a number, $350,000. The Fields would make a contribution to the Affordable Housing Fund, and that would be in lieu of the farmhouse. So then we worked with town council to amend the host community agreement to say, all right, town's not getting the farmhouse, but you are getting $350,000. And at the end of the day, the town's in a better position. They have $350,000, which is well in excess what the affordable units were going for. At Dean Lane, they're going for $235,000, so over $100,000 more. And that money can be used to advance the affordable housing initiative in town. You could buy another unit, and you could buy a unit that would count on the affordable housing inventory. So it puts the town in a better position. They have the equivalent of 4 units, 3 which were built, 1 which is money. The farmhouse is now out of the equation. The planning board's letter that was submitted to you, which we'd seen, raised for the very first time this issue of, well, the house now should be affordable, and it should count in the calculation, both in, as an affordable unit and in the denominator, which, doesn't make any sense. I mean, the Fields would never have agreed to put work into the house, to give the house to the town in exchange for it being counted as one of the required units at Cooper Farm, if it would have just messed up the calculation, because that would have required them to build yet another affordable unit. It doesn't make any sense, and it wasn't part of our approval or discussions back in 2019 when this was approved. On the building permit itself, one thing I do want to point out, in the letter from the planning board, they're talking about the issuance of this building permit being put on hold, and that's not correct. This building permit was actually issued April of last year. Construction was started. They were building the foundation. The building permit was amended this year in May due to some design changes. And we had equipment on site. Work was going on, and at a meeting with the planning board, they instructed the building inspector to put a hold on the permit. So I'm not quite sure technically what a hold is. Maybe town council can say under statute, because I haven't seen that before. But there's a hold been issued on our permit. In the meantime, we've stopped doing work. We want to get back to doing work. We've lost a deal, a prospective buyer who called the planning board office and was told this has to be an affordable unit and walked away from the property. So we're already had a contract that was lost. And this is a significant issue for the Fields. We've made our commitment to the town. We've delivered everything they promised. The 4 affordable units, one is cash, 3 are actual units. And, at this point, we'd ask the board to overturn the decision of the building inspector, who was actually part of the decision to count the house, and then, which ended up being money, as the affordable unit. So it's kind of a bit circular, but we'd appreciate your help there, and happy to answer any questions the board would have.
Okay, does the board want to ask any questions of this?
No, but I need to ask something of our attorney, the town attorney. I realized that I did have a co-broke situation with the Fields 3 years ago. Is that going to be an issue? They didn't. I was not employed by them. Does that make? Do I need to stand down?
What?
They bought a house that I listed, and I was paid by the seller.
No, there's no issue there.
Did you have any co-broke in this development? In the
Absolutely
over
not.
55?
No, I've never sold anything at Cooper Farm.
I don't have a problem with Cheryl.
There's no financial interest in this matter or in the Cooper Farm matter, so I don't think you're crossing any boundaries.
You're fine.
Okay, thank you. Just wanted to make sure. Didn't want anything to come back because I misspoke.
So
I appreciate
I'd like
that.
to hear the response, and then we'll have the board ask questions for clarification or whatever. Mr. Mullen? You want to come up to the podium?
Sure.
And identify yourself, please.
Thank you, Madam Chair, Honorable Board. I issued a stop work order or a hold on the permit on July 7th when they came in to amend it. We were doing the calculations. Town planner Mar and Two Hill ran the numbers. I just checked with the department to make sure they were in compliance with their special permit. I realized at one time I was the chair of the planning board, relinquished that position and took the position of the building commissioner, and now I take direction from the board as their enforcement officer. So I did as I was directed.
So we should talk to the planning board?
Except this is not an appeal from the planning board. This is an appeal from the building inspector's determination. So
Correct.
Why don't we have the board ask questions, and we'll see if we need to invite town council.
Well,
for
if
this
it
guidance.
originally was an agreement with the planning board, I wouldn't mind hearing what they have to say.
I think we still need to ask questions first, and then ask the town council to clarify.
Did the planning board tell you why they wanted to stop?
My interpretation of their direction was that they felt that they hadn't satisfied the special permit requirement for affordability.
And what was why, how had they not met the requirements?
In the memo drafted by Town Planner Maren Toohill, she explains that there is they're missing by 1 or 2, depending on how you look at the math. There's currently 15 units in Dean Lane with 3 affordable. There is the farmhouse that was once an affordable unit that is now privately held, and the town took money in lieu of. The select board accepted it as payment and satisfied the host community agreement. My understanding is that the planning board does not believe they satisfied the special permit requirements for affordability.
Do we need to read Maureen Toohill's letter into the minutes?
We probably should do that. Does anyone have a copy of the 25% affordability clause that's in the old senior residential? I brought an old town code, but I'm not seeing 25% in my copy. Can I just see what section it's in, please? I have it handy if you don't show.
Oh, you want me to read? Oh, I've got my braces in. Do I have to?
I believe it's related to the maximum density. So there's a density allowance of 3 dwelling units per 1 residential unit allowed under conventional subdivision with 75% market rate and 25% affordable.
What clause you in, please?
So that's in the old 173-153 extension of the dimensional requirements on about halfway down.
And that one was deleted in the version that I have. So could you just read that out loud so I can make notes on it, please?
And 3 dwelling units per 1 residential unit allowed under a conventional subdivision with a 75% market rate and 25% affordable. That's so that's maximum density.
And does it say anything about phasing or timing for the affordables, please?
No, it does not.
Okay. And does it reference at all the DHCD count? In other words, DHCD says if you go to 17, you add the affordable unit on that. Does this say anything about an extra unit? Okay. All right. Would you read into the record, please, the memo from the planning board?
I will read part of it, and then I'm going to pass it off because
Okay.
I'm wearing Invisalign, and it's hard to talk, so you'll have to excuse me. This is a letter to the ZBA from the planning board, CC to Mike Mullen, dated August 15th, 2022. Thank you for your time to review the status of the building permits and the number of affordable housing units at Cooper Farm Estates. To recap, the original Cooper Farm Estates development included approvals for 50 housing units, 25 single-family homes, Lot A with the existing farmhouse, and 24 two-bedroom over 55 residential units. The planning board decision is attached, as well as the sheet 3 of recorded plans, which provides an overview of the development as approved. The zoning bylaws in effect for Cooper Farm Estate development requires 25% of the senior residential developments to be deed restricted permanently affordable. The over 55 residential development bylaw also provided the developer with a 3-fold increase in the number of age-restricted housing units that could be developed. Over time, due to design decisions made by the developer based on site conditions, the development morphed into the current layout. 21 single-family units. Included in the last number are 3 deed-restricted affordable, 21 Lot A with the existing farmhouse, and 15 two-bedroom over 55 residential units. Included in that last number are 3 deed-restricted affordable units. There is a building permit application for one more market rate, two-bedroom over 55 residential unit that the building commissioner has placed on hold on this application. The question is whether this proposed new Dean Lane unit must be deed-restricted affordable unit, or it can be sold at market rate. The development clearly has not met the requirement for the 25% affordability. This next unit on Dean Lane must be a affordable unit, and the Lot A existing farmhouse must be permanently deed-restricted for affordability. If the town comes to the determination that Lot A existing farmhouse is to be included in the affordable unit count due to the funding accepted by the select board, then that unit would count in both the numerator and the denominator for the calculation of meeting affordability requirements. This results in 16 existing units that count towards the 25% affordability requirement, and 4 affordable units, 3 of which are deed restricted. However, the additional new Dean Lane unit, the subject of the ZBA public hearing, would also need to be an affordable unit. Based on sales information provided by Jane Field via email on July 8th, 2022, sales price of the units are shown in the columns on the left, and the current status is shown in the columns on the right. And it goes on to list the prices and what the house is sold for. And
I just want to call out that the affordable units that were sold at 236.5, 236, and 236.5, as was represented here. Okay? I think that's good.
so am I asking a question?
You can ask questions, yes.
So what I'm understanding is that if you don't count the farmhouse, then there are 16 houses down there, and 4 of them of which must be affordable to meet the 25%. If you do count the farmhouse, then you're at 17 properties, and 5 of them must be affordable to meet the minimum of 25. Is that what I'm understanding?
That is the interpretation of the planning board and the town plan.
Because
Round up, not down.
Well, yeah, we did that in 40B and, I'm sorry.
Let me see if anyone else on the board has questions. I want to list the questions and hit you all at once as that.
Yeah, I just have one. It sounds like this is written into the bylaws. It's not a negotiation with the planning board's special permit, so they can't renegotiate it down to 3. It has to be based on the bylaw of 4 units. Correct?
Let's add that to the list of questions for council. Keep going. Anyone else?
Certainly in our experience, or my experience, in granting 40B over at Great Road,
15 Gray Road.
15 Great Road, when in question, we didn't allow rounding down. It had to be rounding up, so to speak. So if they built 25 units and a quarter of them were affordable, then it would be over 25% by the time they were done. They could never be under 25%. Is that the rule that you're applying here?
It's the rule that's applied typically through zoning and planning.
Okay, so that's a standard rule. It wasn't just us
Yeah.
being weird about a 40B.
Town boards almost never round down.
Any other questions?
Not right now.
Would we like to hear from planning board before town council? Board's pleasure.
Of course.
Okay. Who is representing or speaking for the planning board?
Actually, we would like town council to speak first.
Okay.
I have a question. I'm trying to understand how the money the town took, how that relates to this calculation.
Okay. I'm going to have town council make a statement based on what he's heard so far, and if he doesn't cover your questions, I haven't written yet. Thank you.
Hello, everyone. Chris Heap from Town Council's office. I guess for my part, I think it would be helpful just to run through the timeline one more time, just to make sure we're hitting all the relevant milestones and sort of talking about the importance of each and who within town was responsible for each. As Attorney Platt said, in 2016, there was a host community agreement entered into between M&M Realty Trust and the Select Board. I think it's worth noting that that host community agreement was entered into. It didn't concern the permitting of the property in any real way. That host community agreement was negotiated over the question of whether the town of Littleton was actually going to buy the entire property. At that time, the property was going up for sale, and the town had a right of first refusal under Chapter 61A to purchase the property. And the agreement was negotiated to, the result of the agreement was that the town did not, in fact, exercise that right of first refusal and purchase the property, but in fact ended up with some open space out of the whole that was agreed to be conveyed to it. So that was the host community agreement in 2016. One of the terms of that host community agreement was that the Fields would donate the existing farmhouse that existed on the property to the town. That was one of several conveyances that were agreed to in contract. The rest is the only existing structure. The rest of it was open space parcels that were indeed conveyed to the town. After that host community agreement was done in 2016, the Cooper Farm development and the Dean Lane project were permitted by the planning board in 2017. Again, that was permitting between the applicant and the planning board. Then in 2021, after some discussion, I think long discussion about what was going to happen with that existing house, the host community agreement between the select board and the Fields was amended to provide that rather that the Fields did not have to convey that existing house to the town any longer, but instead of that was going to make a payment to the town of $350,000 that was to be devoted to the Affordable Housing Trust. So the house, which we were the Fields were contractually obligated to convey to the town, rather than make that conveyance, a payment was arranged for instead. The one piece I left out was that in 2019, there was some discussion in front of the planning board about whether or not that existing house was going to be counted as part of the was one of the affordable units within their permitted development. And I believe there was a vote to say that it would. Although what I understand is that at the time, again, that house was going to be conveyed to the town. And later on in 2021, that changed. And instead of obtaining the house itself and becoming owner of it, the town accepted the $350,000 payment instead. I think the last thing I'll note is the 2021 amendment to the HCA, which arranged for the substitution of the $350,000 for the conveyance of the house, did not specifically address in any way in the actual document how that payment related to the count of the affordable units within the project itself under the zoning bylaw or under the existing permit.
Board members?
So, through our chair, you're saying that part of the original 2016 host agreement had the farmhouse being donated to the town. There was nothing affordable about it. Then in 2000,
I should say the agreement actually read that the house, once donated to the town, could be used for affordable housing purposes or any other municipal purpose determined by the town. So affordable housing was mentioned, but there was not a limit that that's all it could be used for. There was a flexibility to use it for other purposes.
yeah, I seem to remember that there was the question of whether or not Park and Rec would take it over and other possible options. Then you're saying in 2019, the select board, not the planning board, the select board discussed using it as that if the house was conveyed, it could be counted towards the affordable.
That was a planning board discussion, I believe.
That was a planning board, not a
Yeah.
select board.
Yeah.
Okay, so the planning board said that, in 2019, voted that it could be used as part of the affordable housing count.
Yes.
Okay. Then in 2021, rather than make it part of the housing authority count, the Fields sort of bought it back bought their right to own the house, or bought the right to not convey it to the town for $350,000. Is that basically?
Yes.
Right. So they paid $350,000, so now they,
To keep the house.
to keep the house. And, okay, I think I understand. Thank you.
A couple of clarifications for me, please. I heard Attorney Platt say that the house was in fact originally deeded to the town and deeded back. Is that correct, or did I hear wrong?
There was a deed signed and delivered. It was never recorded and ultimately was returned.
And what date was that, please?
That will require some looking.
Attorney Platt, do you have the date on that?
I believe it was given to the town in 2019, is that correct? And then given back when the host community agreement was amended in 2021.
I think you can go by the check date, and look when we got it back,
Could I
Back
also,
was 221, was 221
when we delivered the check.
check.
could I also ask when the $350,000 was paid?
It was done simultaneously. We had, the host community agreement was signed, and then it was held by the town, and our signatures were delivered. We had the check in hand, and there's a string of emails with the town manager at that point. The town was looking to try to locate the original deed, which had been filed somewhere.
That happens in my office all the time.
Exactly, so they found the original deed, and once it was located, Fields came into town hall and they made a swap, check for a deed.
All in 2019 simultaneously with the
All
host
21.
2021.
21. And then, planning board's hearing that you referenced is what date?
October 2nd, 2019.
Those minutes with the decision are in our packet.
Okay. And then, anyone else have questions? I still have the list.
I just a point of clarification, and your timeline was very helpful to me, thank you very much. Part of what you indicated was, as part of the host community agreement, the agreement was that the Fields would donate the home to the town, but it could just as easily been that part of the negotiations of the development of that parcel of land could be that the Fields donated $350,000 to the town. It just happened to be, not that there was a value, but I'm just saying it could have been the discussions, you'll just make this donation to the town of $350,000 and the house would not have been part of affordable or not affordable. That was just the clarification I was looking for. Does that question make sense?
No, not to me.
Okay, sorry.
That's not the way the agreement ended up, but that could have been, a term of the deal if the deal had been negotiated differently.
So if the deal was cash up front, then the affordability or non-affordability status of the field house or farmhouse would be sort of a moot point right now.
I
That's
see what
just
you're
what I was
saying.
trying to
Okay, now I
clarify.
understand,
Okay.
sorry.
Okay, sorry.
So originally, the farmhouse was going to be donated to the town as part of the affordable unit.
No.
It's just going to be donated to the town.
Originally, as from 2016, that contract provided from 2016 that the town would become owner of the house, and that the town, once it became owner of the house, might use it for affordable housing, but the town was not obligated to
That was
use it.
not in the math.
It was not obligated to
So
use it.
originally, okay.
And at the time, just to be clear, at that time, there was no math, because the number of affordable units that the Fields were required to provide to the town only became a question when they applied for a permit under the zoning bylaw. And they didn't apply for a permit under the zoning bylaw until 2017, after they had entered into that contract a year earlier.
So the whole affordable unit thing was not even a part of that discussion at that time?
They were not obligated in 2016, when the
build
contract
any.
was entered into, to provide the town any affordable units, as a matter of zoning law.
Okay, but that was a further negotiation that the zoning board made to allow density or something?
The planning board didn't, the requirement that they provide 25% of their units as affordables existed in the zoning bylaw.
Oh, okay.
So the planning board was obligated to, well, that didn't appear expressly in the permit, but as a matter of zoning bylaw, they were, once they applied for the development they applied for, they were required to provide that number of units.
Okay. Thank you for correcting me.
So, the number of units required under the decision of the planning board was never stated in the decision. It was a function of the bylaw that said you can build this many units, 75 can be marketed and 25 have to be affordable.
I believe that's correct.
And at the time of the application for the permit, they submitted a plan of some sort, and the plan illustrated that there were going to be so many age-restricted units. Let's just focus on that. There were other market units, but so many age-restricted units, it looked like 16, and so 4 of those under the planning board bylaw should have been affordable.
Correct.
Okay. Then the planning board had, in this submittal of the planning board minutes, there's an awful lot of what I consider to be vague and confusing terms, back and forth, and discussions, and it looked like it might have been a joint meeting with select bodies, because I see that Selectman Knox is quoted, Selectman, there's another Selectman quoted, Chase Gerbig was in that meeting, so Selectmen were in that meeting that I think you called 10/2/2019, but I'm troubled by the vote that says, Mullen proposed a motion to accept the house as a count on the affordable units in the Cooper Farm development once the definition of habitable is agreed upon by the Board of Selectmen, and then with the exception of the septic. It's a badly worded sentence, but it sounds to me like the board did vote to call the house a countable unit as early as 2019. And then the special permit didn't contain any change. So I think to me, there's an ambiguity about whether or why the special permit didn't create a change if that planning board voted to accept the farmhouse. Subsequent to that, you say the HCA was amended and the select body said, we're not interested in accepting the affordable unit anymore. So we would like to take money instead, and I guess the Fields offered $350, and that was a negotiated number. It looks like there's some materials submitted that said that went back and forth for a while before they settled on the number. And then the select body accepted the number of $350. Is that about right? That did I miss something or misstate something?
No.
Okay. That's one question. I mean, that was one clarification for me, thank you. The planning board bylaw also that says 25%, 75%, has a lot of provisions in it that say, in the best interest, the discretion of the planning board. I'm just curious about how that plays into what you said, the zoning bylaw can't be altered, and it does say, sorry. Planning board can issue a special permit with any conditions, safeguards, and limitations it deems necessary. So, I don't know, to me, that is where the planning board takes most of its authority to give waivers when they're warranted. And so I don't know if that goes as far as reaching the place where affordability could have been negotiated with and without the farmhouse. That's all I'm asking.
I guess my only response would be that there has been no formal written decision of the planning board on this subject since the original special permit issued in 2017. And I don't believe the applicant has applied formally recently for anything from the planning board on this topic, which leaves, I think, just the zoning bylaw and just the zoning bylaw as the operative document here.
Okay, the zoning bylaw, no, excuse me, the zoning bylaw, the decision of the planning board, and I'm not sure how the host community agreement comes into it,
It really
because
doesn't.
it seems
I-
like the select body
I-
tried to take,
I think it's-
maybe it doesn't, maybe you're
No,
right.
it doesn't.
Yeah,
The
maybe
host
you're right.
agreement started before. The
Yeah,
host
maybe you're right.
agreement really doesn't come into this. And so what the selectmen and the town decided to do with the host agreement doesn't necessarily affect what the planning board agreed to and what our zoning bylaws are. They're getting confused because of this farmhouse that was supposed to be donated, but then was not donated because they gave $350,000. And I'm not sure you can count. I'm sorry, I'm ahead of myself.
Okay, let me go back to the couple of other questions I still had on the list that I'm not sure if they've been answered yet. Is rounding that we talked about, I mean, it's very clear in 40B developments that when they talk about rounding, they round up. And I think Mr. Mullins said, oh, we always do that in zoning too. I don't know that rule in zoning. Is that a rule in zoning? If 25% is supposed to be affordable, do you round up?
I would always round up. Unless the bylaw instructed otherwise, which I don't believe ours
Okay.
does.
And then, I think that, did I get everybody's questions asked? Do you think I hit them all?
Did you have a question?
I did have the one, but I think it's answered, that the bylaw it dictates the 25%. It was not in agreement with the planning board.
Correct. Correct, and not in their decision, he said. Okay. I would like to hear from planning board. I'm perplexed and befuddled.
Are you?
I am.
I thought you were Sherry.
What?
I thought you were Sherry.
No, I'm befuddled today.
Thank you, Madam Chairperson. So, to expand on what Town Council said,
Oh, he wants you to introduce yourself.
oh,
please,
Mark
sorry.
Montanari, Chairman of the Planning Board, sorry. The Planning Board never really got involved in this. It was a host agreement between the Select Board and the developer that they were going to get the house. In 2019, the Planning Board got involved because the Select Board and the developer couldn't agree to the disposition of the house. The Select Board asked us to intercede with it, and we agreed at that meeting that if the field fixed the house, marketed the house, sold the house as a senior residential over 55, that we would count it, absolutely was true,
Mr. Field, please hold your temper, please.
that
Let
we
everyone
would
speak.
count it in the total, that it would become a true over 55. If you look at all the residents there, they're all over 55. Everybody that lives in that project, it's a senior residential over 55, that we would count that existing farmhouse as one of the affordable units. At that time, we were over 12 units, so they were already in violation of their bylaw, because once you hit 13 and you round up, you need 4 units. So that's the agreement that we came upon in 2019 to help facilitate the disposition of the house. In 2021, still hadn't happened. Selectmen didn't want the house because of the condition of the house, I believe, and they're not here to speak about it, but that's the reason that they didn't take it, and they decided to change the deal that they had with the developer and took the house back. The house is not deed restricted, not age restricted, and it was not marketed to a senior. So there is still only 3 units down there. There are 15 units built. There are only 3 units that are deed restricted, age restricted, and sold to people over 55. And that's what the planning board told. When we found out there was another permit out, that's when we told the building inspector to cease and desist. We, at the very least, right now, we need a 4th unit. We're at 15 units, being 16, the 4th unit. The house was never an issue with the planning board. The planning board only got involved to facilitate the disposition of the house, and it never happened. They never lived up to the conditions of making a truly affordable unit. The 350 had nothing to do with the town. with the planning board, as far as we're concerned. It had nothing to do with affordability, it had nothing to do with us. They never came before us to ask our permission to buy their way into an affordable unit. It's nowhere to be found, it was never done. They owe a fourth unit to the senior residential development that says 25% affordability.
So you're saying that that farmhouse was part of the host agreement, not part of the planning board, and the planning board agreed to take it as one of the affordable units at one point?
Correct.
On certain conditions, and that those conditions weren't met, so the host agreement was renegotiated, and the selectmen chose to give the house back to the Fields, so to speak. They returned the deed in exchange for $350. They sold the house back to the Fields for $350, but you're saying, $350,000, excuse me, and you're saying that it didn't, that was all the host agreement, therefore any
Had nothing to do with affordability of that project and had nothing to do with the planning board. The host community agreement was outside of the planning board. We came in and permitted the open space plan and the over 55 after the host agreement was done with the select board and the planning.
So let me ask this question. If indeed they had fixed the unit up, and if indeed it had been marketed and sold, all the conditions you're saying were met to make it an over 55, if they had satisfied the planning board and it become marketed and sold as an affordable restricted unit, that would give them 4 out of, you're saying 17.
16 at that time, 16. We're still only at 16.
We're still, that
We're
would
at
be
15
4.
right now, we're going to 16. That would have satisfied.
So there
our
would be
special
4 out of 16 then. And if they did another house, then that one, if they had met all their goals, it'd be 4 out of 16.
Correct.
And to build another house, then that last one would have to be affordable also.
As well, correct. That's what Marin's letter is trying to say to you. No matter what happens, that's the 7, if you count this as an affordable, which we do not, the planning board does not agree it's an affordable unit, that would have been the 17th
Well,
unit.
they're making the case that because they paid $350,000 for what should have been an affordable unit, then it should count as part of an affordable unit. What I'm saying is that if they're right, we're still looking at 17.
And yes, that's what Marin letter says to you, but in order for that to be an affordable unit and for order for them to pay the $350,000, they need permission from us. They can't do it with the selectmen. We are the special permit granting authority for that over 55. They would have had to come to us and say, hey, we don't want to build another house. We'll give the $350,000 to the town, and they would have had to get a decision from us that said that we were okay with it, because we are the special permit granting authority. We are the only ones that can make those affordable. We're the only ones that can do it. Their agreement with the selectmen was purely about the host community agreement. It had nothing to do with affordability and the units down at the over 55 at Cooper Farms. They got a density that nobody else in town got, and the condition of that was 25% affordable. They're in violation now. They've been in violation for over a year and a half, because once they got past the 12th unit, they need a 4th unit. Rounding up.
I seem to remember we requested, we forced Seal Harbor over at 15 Great Road to make the first of every 4 or 5, because we were at 20% with them.
Yeah, that was contained in the decision. This didn't have a phasing in their decision. Mr. Mullen, you had your hand up when you started. I hope you don't forget.
Going back to when I was chair of the planning board, I just want to make what I believe to be a correction to Mr. Montanar's statement. We did vote to count it as an affordable unit. However, we did not want to age restrict it, because we did want to be able to count it in the town count for affordable units not being age restricted. Outside of that, we had talked about making it available to, town employees, municipal employees, firefighters, police officers, teachers. That was a discussion when I was on the planning board as chair. So that's the only correction I wanted to make in my recollection of that decision in discussion.
But it was going to be deed restricted and sold, correct?
No.
Yes.
So my recollection is coming to the town.
Never did that either.
It says, Mullen proposed a motion to accept the house as a count on the affordable units in the Cooper Farm development, once the definition of habitable is agreed upon by the BOS, with exception of the septic. I'm assuming that back end of that means Board of Selectmen was supposed to go through and make sure it's livable, and then the agreement was it would be donated to the town as an affordable unit, or for whatever purpose they wanted. You would count it as an affordable unit on the planning board special permit, and everyone understood that Fields weren't going to put the septic system in it. And that was subsequent to the HCA. So even though we say the HCA is not a part of this, that proposal was brought before you by the Fields, it looks like, asking you to consider that home as one of the affordable units. Now, I get that they didn't market it. I get that it wasn't properly marketed to be counted in the count for the Littleton housing inventory, but none of the units that are affordable down there will count anyway in the Littleton housing inventory because they're age restricted. Is that a correct statement? Okay, because the age restriction that used to be okay is no longer okay, it's discriminatory. So they won't count those units. It's a moot point, I'm just making factual comments here because there's a lot of information flying. I don't have any people from the select board here, do I? And is anyone else on the planning board wishing to speak? Mr. Yates, you want to come up, please? Thank you.
I'm talking more as a observer. I was on you, with you guys, when all this was going down. But I'd like to point out that the thing that bugs me the most is that the town sold the house to the Fields they can sell it again. They could tomorrow put it on the market for $600,000, for $700,000. The fact that the money went to the Affordable Housing Trust is a red herring. It could have gone anywhere to the town. But the fact remains that that house, which was intended, I think, by the Coopers and the town to have some public benefit, the only benefit that it has now is to the Fields.
What about the 350? Where is that?
The 350 there's a check that's still somewhere in the town offices. It hasn't been assigned to anything. The intention is to go to the Affordable Housing Trust. But my point is that that is not a substitute for real affordability of that property, which then means that the town is owed 4 units. I understand from a legal point of view that there's this meeting and that meeting but the basic thing is 16 units, 4 deed-restricted affordable units. I think the point about the subsidized housing index is good because we are well above, we're not digging deep for units to go onto the housing index. And anyway, but I really want to leave in your mind that house is privately owned now and has nothing to do with affordability. It the sale of it may have benefited an affordable component, but as it goes forward, it's not an affordable unit. So that is complicated also because, I guess the point is, from Marin's point of view, is if you decide that it was somehow to be counted as an affordable unit, it would increase the denominator so that it would have to be affordable. So from my point of view, from the Fields, you're well ahead to have the 4 units that you built and own the farmhouse. That's all.
Thank you. Mr.
No, you never stated your name.
Thank you.
Our town administrator was shaking his head. Would you like to say something, Anthony?
The $350,000 was cash.
Can you and introduce yourself? I'm sorry.
No. Yeah.
Anthony Insaldi, town administrator. The $350,000 was cashed. It goes into, because of municipal finance laws, although the check did indicate the Affordable Housing Trust, we had to put it in the general fund. We anticipate putting a warrant article. We had to wait till this special town meeting to then transfer it into the Affordable Housing Trust, or we'd prefer to put it into the CPC, get the match, and then put it back to the Affordable Housing Trust.
So just for clarification, when you say the CPC, if you put it through the CPC to the Affordable Housing Trust, it doubles because the state will match it.
At 30% or whatever it might be, yeah.
Okay, thank you. I want to speak to any abutters. I see a lot of residents from Cooper Farm here, and I just want to hear why you're here. Does anybody want to speak? You're a community your community to whom this decision may make a great impact. Please. Please.
That be sold as a fair price unit, not an affordable unit. I think it's going to be hard.
One second, can I just ask your name for the
Oh,
record?
sorry, I'm Carolyn Cochran, and I live in Cooper Farm.
And what unit are you in?
Lane 12.
Thank you. And you said you would prefer that it be sold at market,
Yes,
and can you tell me why?
yes, because I think it's a small lot. It backs up to the berm, so it's not an ideal lot, number one. So they're going to have to build a specialized house on it. I think if it's an affordable unit and the Fields decide not to build on it, they can't even sell it. Because who's going to buy a lot that you can only build an affordable house on? And I find it personally irritating that we had a buyer for it. There was a buyer for it. But now they've lost out on that.
Buyer right here for it, too.
Can I hear from someone else, please? Thank you. Did you raise your hand? Would you like to speak to this? You raised your hand.
Oh, no, I was just proposed buyer.
He's acknowledging.
Oh, you're the proposed buyer.
Madam Chair, I make a motion to close the hearing.
Does anyone else have any questions of planning board? Does anyone have any questions of town council? And do you want to do a summation and wrap up before we close?
Thank you, Madam Chair. There is a lot of history to this property and to this development, and there were a lot of parties from different boards of the town involved, and we've tried to be open and deal with all the appropriate boards at the appropriate times. The farmhouse definitely did become a focus, and we had meetings where they're at the planning board with members of the select board there. We had, and just to go back a little further, that host community agreement saying that the Fields would donate the house, it also said if the town wanted, they would move the house, or, consider even demoing the house. The house did not have significant value. You can look at the assessor's records from when it was back in 2015. The only value was put into it by the Fields after they purchased it. There was so much work done that at a meeting with the planning board, with input from the select board, who was members of the select board who were at that hearing, decided they would count that unit if the Fields did renovation work. And it was a long list of work. So they said, yes, we'll count it as an affordable unit, which was helpful for us, but it also was helpful for the town in that they would get significant improvements to the house. Those improvements were made. The Fields did honor their commitment to the town. And when the inspection was done on site with members of the select board, members of the planning board, I believe the town administrator was also at that meeting, or that site walk, realizing how much money the town itself would have to put into the house to have it to sell it as an affordable unit, to put in a new septic system, would be a significant monetary undertaking. And the select board suggested that the Fields make a cash contribution, which we negotiated and we agreed to take in lieu of the house. And to town council's point, yes, we should have gotten the planning board to amend that special permit. We thought that their decision, as reflected in their minutes, was sufficient. We are now, because there seems to be lack of communication, we thought we had representatives from both the appropriate boards at the site saying that, yes, we want the money instead of the house. Everyone was on board. There is correspondence between me and town council when we were amending the host community agreement saying, Chris, think this is a great deal for everyone. Do we need anything else in this agreement to confirm that this counts as our affordable unit? Happy to submit that. So we believe that we've done everything that was required, that there's essentially 4 units, 3 that were built, and the cash in the Affordable Housing Fund, so if the town wants to buy a unit, they have it. They have the capacity, they've had the money for 2 years now. You can go at any time, well, once it's approved, can go get another unit, and the 4 units will be met. There will be only 16 houses in Dean Lane, 25% of that will be 4, and that's it.
So, Attorney Platt.
Yes, ma'am. Madam Chair.
How do you respond to the argument that I've heard here tonight, that even if we were to accept the proposition that the planning board's decision made the farm an affordable unit, even if we were to accept that proposition, doesn't the next unit become number 17, and don't you owe another 4 or
Another
the
unit?
17?
Absolutely not. It's not in the 55 and over development. That 25% restriction doesn't apply to any of the single-family homes on Cooper Farm, didn't apply to the farmhouse. It only applies to the 55 and over. Those are the only units that are part of the denominator for the 25%. The farmhouse was
It's not part of the HOA.
was a creative discussion between boards on something that could be helpful for the town, helpful for the fields, and it's within the planning board's discretion as a special permit granting authority to grant the special permit. This was an agreement to amend that special permit.
So you're.
I have, excuse me, I don't mean to step in your words, but I have not a solution, I have a creative idea, and I just thought I would put it out there. We have 100 days to act on an appeal, and I want to poll the board, which I always do, and from what I've heard from my colleagues on this board, it doesn't sound like they're buying the argument of the appellant. I'm stuck on the notion that because this isn't countable in the affordability thing, I'm not sure that that there's a requirement that it has to be affordable according to the Department of Housing definition of affordability. And I'm not sure that there isn't a compromise solution that might be met here with planning board. I personally think that the fault lies in this whole thing with select body trying to negotiate a host community agreement and almost taking over some of the responsibility and jurisdiction of the planning board. Select body isn't in the business of designing projects and deciding which are affordable and which are not. I'm personally a little troubled by the ambiguity of the planning board vote, but I'm hearing, and I think you've convinced me that that makes the 17th unit, and that troubles me again. Anyway, I'm also thinking that the $350 that's sitting there in the trust might be utilized to fund the build-out of this last unit to be offered as an affordable, and that might be a creative way to go with this. What I'm suggesting is, before I allow this meeting to close, do you and the applicant want to consider another return to the planning board for further negotiation? Because this board is not going to be able to vote anything but uphold or not uphold the building inspector. We can't do anything about the unit and deciding what's affordable and what isn't. We can just say yay or nay to the building inspector.
I think we need to have a discussion, Madam Chair.
We can have a discussion. I'm asking the applicant if they want to ask for an extension.
We ask you, what is house? The one that over 55 house?
You can ask that of the
So this house that's
attorney.
been, the building permit's been held on, is this going to be an over 55?
Yes.
Okay.
With the special zoning
Well, that's what I'm
provisions
saying.
for it.
That's what I was wondering.
It would be an age-restricted in
Age-restricted.
perpetuity
So that-
over 55,
That's a
as
17
are
units.
all of the all of the units in the development.
I think we need to close the hearing and make a
Yeah, I
decision.
just want to make
I
sure.
think we need to poll the board, which is what I do on every hearing, and you hear what the members are thinking.
Mhm.
And then you can decide if you want to let me close or if you want to ask for continuance, which I would do on
Fair
any
enough.
hearing.
Appreciate it.
Okay. Where do you want to start? Do you want to speak first?
I think we need to close the hearing and have a discussion among the members and make a decision on this. I think that's appropriate. I think I'd like to listen to my fellow board members on what their thoughts are and why they have their thoughts, and I would like to have a discussion and make a decision. I don't think it's appropriate to send them back to the board to renegotiate. I don't think that that's why we're here. I think in this case, we really should be having a discussion among ourselves, close the hearing, have a discussion, and make a decision.
The trouble is, once you close the hearing, we can't ask any further questions or enlist any more information from anyone. And I think that as we have this discussion, we're going to have more questions, as John just said. So I have no opposition to what you're saying, and I have no opposition if the conclusion is to close the hearing. But I would like to hear from all the board members about what they're thinking. Is that all right? So I want to start, maybe. Kitty, you want to start? Do you feel brave enough?
So, the information that I received tonight, mostly from Attorney Heap, as well as Mr. Mullen and Mr. Molinari, really fleshed out some of these issues that I was not privy to at the time. So I think, to me, the sequence of events sort of crystallized, and I feel at this point that I could make a decision about this particular question. Do we support Mr. Mullen's decision or not? I feel comfortable, given this new information that I received, with a firm response that I feel I could support in terms of enumerating how I got from A to Z, which I didn't have before I walked in here, because the information I received wasn't terribly complete. There were the ambiguities that you pointed out, and I didn't have the background. So that's filled in for me now, and I'm always happy to continue discussing things because I always learn something, and there may be more information that comes forward to help with some of the nuances.
Okay, John.
I agree. I think that, we've heard both sides of the story, and the story behind the story, and I'm ready to discuss it and make a decision.
Sure.
I think I can make a decision. I'd like to have a discussion with my fellow board members.
Okay.
Do you want an explanation, a discussion, or, because I will second that motion to close the hearing. But, my feeling is, there's 15 units now. We cannot change the bylaw. The town meeting only can change the bylaw. So it requires 4 affordable units. And that's not counting the farmhouse. The new unit would make it 16, that's still 4, so the new unit would have to be affordable. If they want to add the farmhouse in as an affordable unit, the new unit they want to build becomes 17, requires 5, therefore it still has to be an affordable unit. And I would uphold the building inspector.
Then you want to renew your motion?
I make a motion, we close.
Eli.
Oh, I'm sorry. I thought I started there.
That's okay. I agree there's sufficient information at this point. The information that we were passed along was missing some of the backstory, but that was helpful to get tonight as well.
It's rather compelling, isn't it? It's interesting. I make a motion, we close the hearing.
And second? Okay. All those in favor of closing the hearing?
Aye.
Yeah, I came in thinking that that was an agreement with the planning board, but as soon as it's the density requires by the bylaw 25%, that set my direction.
I keep wanting to have sympathy about the $350,000 that they paid to buy the house back. But I would, in my mind also, is the fact that I just sold a one-bedroom tear-down house for $275,000. So buying that house back from for $350,000 doesn't seem that onerous.
I want to just stop you because that's not relevant to the discussion, really. And today's market is not what it was when they bought it back in 2021. So stay on focus on the,
Okay.
the building inspectors.
Then I am persuaded by Maureen's argument that as Rod said, that if we count the farmhouse as an affordable unit, that makes it 17. If we don't count it as affordable unit, then we're still at 16.
Eli? John?
That's, but I see it's exactly what you just said. So it really doesn't make a difference about the farmhouse, because if you count it as affordable, you now need, and you build this extra house, you're at 17, and that requires 5. Now you still count the farmhouse as affordable, but you still need 4 more, and you only have 3. If you don't count it at all, just ignore it, then building the 16th unit, you still need a 4th one. So whichever way so the farmhouse, whether it's an affordable or not affordable, really doesn't fall in the calculation at all. Only if they decide not to build the 16th unit at all, then they can just stop and walk away, and they meet the four units because then we're at 16. Right now, we're at 16.
No, we're at 15 now with 3. So
No, we're at 16 if we include the farmhouse right now. And if we include the farmhouse as affordable, then you got the farmhouse and 3 more. It's when you decide to build this 17th unit, what I'm calling it, even though it's actually the 16th being built, it's still the 17th affordable unit, or over 55 unit, which then pushes you up to needing 5. And at that point, the farmhouse, and then you need 4. So they could walk away right now and not have anybody come after them for not meeting the 25% because they're there. But if they want to build this last unit, then it has to be affordable.
So you're saying you would count the 350 as an affordable unit if they stay where they are?
No.
Yeah, I would say it is,
I'm confused.
and whether the selectmen had the right to do it or not, I don't want to punish the Fields for that sideline that probably shouldn't have happened. But it's there. So we either have to include, you have existing 15 houses plus the farmhouse. If we stop right now and we let the selectmen use the selectmen bought it as an affordable unit, and you have 3 more that were sold as affordable units, then that meets the bylaw. As soon as they go to build this next house, that's when it pushes them up, needing another affordable. So at that point, they would have to build it as an affordable house.
Can I
And
just,
also, that farmhouse, even though they say it here, would have to be restricted over 55 and affordable if they.
can I just clarify that we are not, nothing we say here tonight dictates whether that farmhouse is counted as affordable
understand.
or age-restricted or anything. We are only here to determine if the building inspector acted properly in denying
Right,
this
so
permit.
if we.
That's all we can do.
So if we decide, and you say the farmhouse was not sold as an affordable, so if they want to build another one, they need to have an affordable
So
unit.
what Sherry just said is we can't dictate whether or not the bylaw is satisfied. That's up to the planning board, not up to us.
And the building inspector. But yeah, but that's what we're saying. If we uphold the building inspector decision, then that is what we're saying, that the next one needs to be affordable.
They need
That's-
to create an affordable,
Yeah.
not the next one. They're one short.
Yeah.
So they have to create one.
Well, that's up to them, I think. That's up to the planning board and further if they come back to us, I think is what Sherry's saying.
Yeah,
Right now, our only decision is whether or not to uphold the planning board, the
building
building
inspector.
inspectors.
Which is actually the planning board, because the building
Instruction.
inspector told us he did it based on their direction.
And Kitty?
So, to me, Mr. Yates's comment that the 350, the affordable, how the farmhouse is treated versus the 350 is a red herring, goes back to my clarification to town council that when the host community agreement was negotiated, that they just used the house as a donation. We'll give this back to you, and then it morphed itself into $350,000, which the town manager has indicated is not in fact earmarked for affordable housing or that pot until there's a warrant, et cetera. So saying that it's in lieu of is not a correct argument to present, because that is not true until it is true. And so I think if we take some of the transactions that have gone on between the creation of the host community agreement, if we just replace everything around that farmhouse with money, I think some of the issues to me just, smooth themselves out. And when you do the math, they're one short from the 15, and they're going to be another short because they still only have 3 verifiable affordable houses in that whole building. So the farmhouse is clearly not, at the moment, an affordable unit. It was returned and then sold, and it's not restricted as you indicated it needed to be. Again, not our purview, but the math is the math to me, that they're at least one short, and to me, they're 2 short of the affordable based on the totality of the information I've received. If you take all of that back and forth that the select board got into with this house and the planning board's role of permitting, which Mr. Molinari made clear that happened well after, and that's their job to do that. So I don't see how I couldn't vote to uphold the building commissioner's decision.
Yeah. And if I read some of the later discussion, it sounds to me like however you want to deal with the farmhouse, whether it was given, sold back, or whatever, was being considered in lieu of the 4th unit, I don't think is an acceptable approach. It can't violate the bylaw. The bylaw says 25%. It doesn't allow something, to not do it because the town got a $350,000.
Only the planning board can do that.
I'm not sure the planning board can either, because it's a bylaw, it requires 2/3 votes at town meeting.
There's some weasel words in there in that zoning thing. Sherry read the weasel words.
Yeah.
Weasel words in that.
Oh, the weasel words in the zoning
There are some
thing.
weasel words in there
But you
for the
know
planning
what?
board, but they didn't, is what they're saying.
Yeah.
The board's very clear. I'm hearing very clearly that you're ready to make a decision, and I'm certain that whatever the decision that we make that sounds like it's headed toward upholding the building inspector is not going to preclude the Fields from going back to the planning board and making some effort to make this less, to hurt less. So I'm ready to take a motion if somebody's ready to make it. I think we've exhausted discussion.
Okay, I'm not exactly sure how cease and desist was issued, but I move we uphold the building inspector's decision to not allow a market rate house to be built on that 17th lot.
I think the wording was put a hold on the building permit, right? Just uphold the building inspector's decision to put a hold on the building permit for that last unit.
That would not apply if they were.
Let's reference the number. It's Dean, EAU 19/20,
Yes.
Dean Lane.
Okay,
You're making that motion. Who
to
seconds?
uphold the
I'll
building
second.
inspector's decision.
Sewell seconds. All those in favor signify by saying aye.
All right.
Aye.
All those opposed? FP 2137. Okay. I think you as a board did an excellent job. You were deliberative and fair in your open-mindedness to hear the story on all sides.
I make a motion to close the meeting. Can we do that?
Yeah.
I'll second that.
All those in favor signify by saying aye.
Aye.